Good morning, and may it please the court. Spencer Scharf on behalf of defendant appellant Charles Langley, joined by my co-counsel Jim Bellinger. I will endeavor to reserve 5 minutes for rebuttal. Mr. Langley is entitled to qualified immunity because he did not violate a clearly established constitutional right. Even at the pleading stage, it is plaintiff's burden to show that the rights allegedly violated were clearly established. Yet plaintiffs have not identified any controlling authority that existed as of January 2016 that would have clearly informed Mr. Langley that his conduct on the night in question violated a clearly established law.
Okay, I'm sorry, counsel.
Please.
It's not clearly established that an unarmed person who poses in the circumstances no danger, that it's not clearly established that you can't set rules of engagement, that if you make a mistake or you move, we're going to shoot you dead? It's not clearly established that that violates the Constitution?
Your Honor, I would disagree with your characterization of the allegations.
Well, I'm reading it. Your client's, it's alleged, and again, as you say, this is at the pleading stage. If you make a mistake or another mistake, there's a very severe possibility you're both going to get shot. If you move, we're going to consider it a threat and we're going to deal with it and you may not survive it. I mean, maybe your client didn't say that, but that's what he's alleged to have said, right?
Yes, that's certainly the allegations.
And then the person under his command fires 5 shots and kills this person who's crawling toward your client on the floor, as alleged.
As alleged, yes.
So I don't understand how that comports with any reading of the Constitution.
Well, Your Honor, the allegations of what was commanded or warned are warnings that are constitutionally required before deadly force is issued. The suspect needs to understand the gravity of the situation, that if they don't comply with the officer's commands, the deadly force could be used. And all of the case law that is cited by the plaintiffs to establish this clearly established right, Graham, Garner, Harris, Diorly, are all cases, one, where this Supreme Court has specifically admonished this court from relying on outside the obvious case. And here, this is far from an obvious case. Mr. Langley did not use any force.
What makes you say it's far from the obvious case? I mean, if in fact the allegations of the complaint turn out to be true and you have somebody who does not, according to the allegations, pose a threat, how is it that that's not an obvious case that a police officer is not allowed to shoot and kill him?
So two important facts that are alleged is that as alleged, Mr. Shaver did pose a deadly threat. If the court considers the allegations as true, as they must at this stage.
What was the threat?
The threat was these officers were responding to a report of an individual pointing a rifle outside of an elevated position.
In his T-shirt and shorts, does he have a rifle hidden someplace?
Well,
Did the officers do anything to pat him down to see if he's carrying a weapon?
So as alleged, the officers were, the plaintiffs make clear that the individual who had the rifle in the room did not match Mr. Shaver's description. So as alleged, when they're in this hallway, they still have to operate under the assumption that there's another man in the room with a long rifle. And the plaintiffs are very...
Stop, because that doesn't tell you why the person who's crawling on the floor poses a threat such that the Constitution allows an officer to shoot and kill him. If that person isn't carrying a rifle, that person doesn't really pose a threat, does he?
So as alleged, they...
Answer that question. How did Mr. Shaver pose a threat?
Well, he could have had a concealed weapon on him.
But no effort was made to find out whether he had a concealed weapon, and he sure didn't have a rifle, given how he was dressed.
There was certainly an effort made to ensure that he didn't have a concealed weapon, and that effort was to secure the hallway. And as alleged, another individual listened to the same commands and was taken into custody safely. The other important point is...
So you're saying it's his fault then, because he happened to stumble a little bit during the crawl up the hallway? So he should have got shot?
That is not what I'm saying, Your Honor. What I'm saying is this is an objective standard of what a reasonable officer should do, And the defendant appellant who is before this court is not the officer who used force, excessive force, no force was used by Officer Langley.
I mean, if you watch the video, he's the one giving the commands, correct?
The video was in part of the pleadings, but yes, as alleged, Mr. Langley was, and as in fact, was the only officer giving commands.
Okay.
And if the court were to look to its own precedent, and which is why I think it's important to do so, those cases, Diorly, Graham, all emphasize the importance of when considering the totality of the circumstances of whether a force is reasonable, is whether a warning was issued. And
Well, and that's another part of the problem here, because it's not simply whether a warning was issued, but whether what could be described as rules of engagement are stated in severe terms multiple times, thereby arguably giving notice to the police officer who did fire the shot. This is what you're supposed to do, basically be a hair trigger. If this guy moves an inch in the wrong direction, the rules of engagement set by your client suggest he could die, which is in fact what happened.
if the court wants to conclude, and again, we would disagree with it, the court wants to conclude that these rules of engagement, however you characterize them, it was a constitutional violation to give commands in this manner. The court clearly can give that guidance to officers. But as of January 2016, there was no precedent that could inform Officer Langley that this type of warning, these types of commands, clearly violated Mr. Shaver's rights. In fact, in Diorly, this court said, as the individuals walking towards the officers, that that the failure to inform the individual that he would be shot if he continued to walk forward was a factor considering that it violated his rights.
Counsel, with respect, I think as alleged here, this is significantly different. You have there was a apparent threat of somebody else with a rifle. The person who was shot didn't have a rifle. The rules of engagement are crawl on the floor, put your legs behind you, cross them, and if you make any mistake in moving toward us, you're likely to get shot. I just don't see how there isn't fair warning that when that results in the person allegedly under the command of your client getting shot 5 times while he's crawling toward the officers, that there isn't a clear precedent that the shooting as alleged is unconstitutional, and that the person who sets these rules of engagement can't be held liable for that if the facts prove to be true.
Well, Your Honor, I think Kuhnle, which is again another Ninth Circuit case that went up to the Supreme Court, provides some guidance there. There was no warning given, and it was the officer who actually shot who was the defendant, and the Supreme Court said that there was no clearly established law that would put this officer on notice that shooting that individual would violate the Constitution.
That individual had a knife, correct?
Yes.
Okay, did this guy have a knife? Was a knife seen on the floor when he was crawling down the hallway?
Again, 2 things. One, again, my officer, the officer that I represent did not.
No, I understand. I didn't say that. I said when the guy who was shot was crawling down the hallway, was there any sign of a knife?
As alleged, the officers were given information. Now, they allege that it was bad information, but the hotel and the 911 officers gave the officers the belief that he was a deadly threat.
Well, you just said he didn't match the description of the person that was given, correct? As alleged.
Again, we have to look at this not in hindsight, but with what the officers were looking at the time.
Well, we have to look at what's in the complaint.
Yes.
Okay. So in the complaint, does it allege that the man crawling down the hallway had a knife?
No.
Okay. Do you have any reason to think he did?
As alleged, no.
Okay.
But again, officers have to assume that when they're responding to a situation that involves a gun, that individuals are armed.
So what if there was a kid on a tricycle in the hallway? Could they have shot that guy too?
Again, we're looking at whether it's objectively reasonable for them to consider this was a deadly threat. And, if things had turned out differently, obviously there have been situations where individuals have taken long-arm rifles at an elevated position at a hotel.
Right, but this guy was on the on his underpants on the floor of a hallway. I mean, I could see this case being different if there was someone actually in the hotel room. That's a totally different case. But here, with a guy in his underpants on the floor of a hallway in a hotel, it's hard for me to see how this is the same as Casella.
Again, but this is a very different facts. All those cases are dealing with the officer who used force. Again,
Right.
this is not.
But at this stage in the pleadings, I don't see how that matters, quite honestly. If an officer is, the plaintiff's theory, as I understand in this case, and they'll have a chance to come up and explain this to me, but my understanding is that this guy kind of set the tone. This guy kind of set through his commands and through his actions. He kind of helped create a situation where this would be the end result. He may not have been the guy catching the touchdown, but he might have been the center hiking the ball, if I can use a sports analogy. So if it's a team effort here, if that's the allegation, and we're at the pleading stage, I don't think trying to differentiate between him being the shooter or not is going to help you much.
Your Honor, this court has rejected the notion that team effort is appropriate in 1983 cases.
What
they did
case
so
is that?
in Schumann. That's the 1996 decision, where that's one of the first times this court recognized the integral participation standard, and that was specifically rejecting the team effort standard of liability.
So you're saying since 1996, there have been no Ninth Circuit cases that have held anyone liable for not being the shooter in a case where someone's shot?
If you look at all of the integral participant cases that the plaintiffs cite, none of them are shooting cases. They're all CPS, custodial cases, search warrant cases, where the violation is an unlawful search. They're not unlawfully use of force cases.
Is there any distinction, real meaningful distinction between the two?
Yes, I think it's about what the knowledge is. There's a plan, there's a collective decision. The court has emphasized in Surgiset and Keats that the officer, in order for them to be held liable for another officer's use of force or other officer's unlawful conduct, they have to have a knowing participation in the unlawful conduct.
Not talking about one of the other officers that was armed and did not shoot. We're talking about the sergeant who is giving the commands that allegedly encouraged the officer who did fire the shot to follow the rule of engagement. If you move an inch out of place, then you may be shot. And that's in fact, so I think the allegation isn't simply that it's a team. The allegation is that your client knew the commands he was issuing and set up the risk of what actually happened. I mean, it may not prevail, but
as alleged, though, Mr. Shaver didn't make a mistake. So there wasn't any even if assuming that's true, there wasn't, Mr. Shaver fully complied, so there was no authorization, even if you accept this as and again, we would disagree, characterization as an authorization to shoot on a mistake. As alleged, he did not make a mistake. And so if there was a risk, that it was one of negligence, not a one of intent, and clearly that's important at the 1983 stage.
Your client is alleged to have authorized pointing these deadly weapons at what would appear to be an unarmed civilian and saying things like, allegedly, if you move, if you make a mistake, and the allegation is that he tripped over a purse, or in crawling over the purse, he made a movement back toward his waist, and that's what led to the shooting pursuant to the rules of engagement. I just think that none of this may prove to be true, although I think we've all watched the video, but I just think at the pleading stage, there's more than enough in the complaint.
Your Honor, and I know I've read your opinions and watched these arguments in front of in 1983 cases of similar nature. The question is, what case, what controlling authority put Mr. Langley on notice? That's the important question here. And if your honors are troubled by these facts, your honors can publish an opinion that provides guidance and notice for an officers in the future. But here, under the qualified immunity standard, an officer must be put on notice before they're held.
It's also observed some situations are obvious enough that the general principle should be enough to let the officer know what is and is not appropriate. And I'm not sure why this doesn't fit. Even if you can't point to a case with the same kind of facts, it seems for me, my perspective, that may qualify as what the Supreme Court would agree is pretty obvious.
Again, those are all cases where it's the officer who used force, not an officer who is on scene with an officer who used force. And I'd like to reserve some time if possible. Thank you, for your honors.
Thank you, counsel.
May it please the court, Bill Richards on behalf of Appalese Laney Sweet, her minor children, and the estate of Daniel Shaver. I'm going to use no more than about 10 minutes and reserve 5 to Mr. Budge, who represents the Shaver Appalese as well. The court must affirm the district court's denial of the motion to dismiss because, in fact, as the court has acknowledged, I think all 3 judges have acknowledged, the shooting of an unarmed, compliant, surrounded, non-threatening citizen is a violation of the most clearly established constitutional law we have in American jurisprudence. And because the well-pled allegations of the Sweet plaintiff's complaint alleges detailed facts taken from the video, the transcript of the video, and the interviews of the officers afterwards, and in fact their testimony later on, that establishes not only did that sort of constitutional violation occur, but establishes multiple plausible bases to hold Appellant Langley liable under either this court's supervisory liability standards or under the integral participation standard that this court has also adopted, for example, in the Boyd versus Benton County decision. Let me get directly to answer Appellant's argument that there was no case law in this circuit or elsewhere that would have allowed Appellant Langley to understand at the time that he gave orders, directives, and set things up to establish the rules of engagement that resulted in Daniel Shaver's death, these reckless rules. I think the court need only look so far as the Harris decision, where in 1997, this court held that I believe 12 separate federal officers could be held liable under supervisory liability principles, where they changed the FBI's rules of engagement to allow snipers to shoot at any armed person who appeared on the property. They were all held, the court held that they could all be held liable for supervisory liability for that clearly established constitutional violation. But, Your Honor, Appellant is also wrong to suggest that we haven't cited any cases involving police shootings out of this circuit. Your Honors, again, we have cited the Book decision. That involved AR-15s being used against an unarmed individual who was standing in a planter, and the supervisor who did not shoot was, the court held, could be held liable under the supervisory liability and integral participation standards. In addition, the Diorly case does not involve a shooting with a lethal weapon, it involves shooting with a beanbag shotgun. But in that case, again, the court held that the supervisory officials who put that in play could be held liable. And the estate of Crawley decision, unpublished decision, though it is a very recent decision out of a district court in California, uses this court's clearly established law to establish once again in that case that a supervisor who did not participate in the shooting but nevertheless condoned the activities by which the other officer who did the shooting would breach the home and confront what they knew was a very erratic, upset individual who they believed to have a golf club and was swinging it. That supervisor who allowed those rules of engagement and those rules of operation to go forward could be liable for a clearly established constitutional violation in the shooting. There's plenty of precedent, Your Honors, in this circuit.
We have cases where rules of engagement, we're using that term, so I'll stay with it, but the general command is met. In this case, I think it's potentially significant that that was one officer who fired all these shots. The other officer hearing the same instruction, they're all there, they're not doing anything, and it could be fairly argued that the sergeant, in trying to give a warning, take control of the scene, wasn't expecting somebody with a loose trigger finger, because again, it's hard to break down exactly how it played out, but at least according to the allegations, it's not like the victim clearly disobeyed some order of the kind that might lead an officer strictly following the instructions to take action. And so the sergeant may well have been surprised that after trying to seize control of the situation, he had the misfortune of having an officer fire anyway. What case gives us guidance or would give the officers guidance in that situation?
Sure, and Your Honor, there are two separate things to be considered there. Let me jump to one that goes a little bit beyond your question, but I think will inform the second answer I have. The first is that according to the complaint allegations, what happened is Sergeant Langley and his entire team, when they got back to the station, they all created reports that omitted any mention of Daniel Shaver being scared, being compliant, begging not to be shot. They omitted the specific explanations of the orders that were being given by Sergeant Langley, and all of the officers reported instead that they all perceived an imminent threat at that time. So for them to suggest factually that, look, we didn't anticipate this was kind of came out of the blue, if those were the facts, Your Honor, that it really was something completely aberrational, for example, he didn't even know that this officer had a weapon out, that may support that sort of an argument. That is not what happened here. In fact, what happened was it was Sergeant Langley who set the entire process in motion. He selected the team to go with him. He selected Officer Brailsford. He knew who Officer Brailsford was. We've given you background of Officer Brailsford in the complaint. He was a fairly young officer who had some prior problems, allegations of use of force problems. Sergeant Langley picked him to go. He picked Officer Brailsford to use the AR-15 rifle and to be 6 feet away from Daniel Shaver while he commanded Daniel Shaver, under threat of him being shot, to move forward toward the officers. He gave the commands that indicated he could shoot if there was another movement of the hand or a mere mistake. And Your Honor, in addition to that, the complaint demonstrates, as does the video, that Sergeant Langley ordered Daniel Shaver to crawl forward over, giving him these sort of commands, over a large purse that Sergeant Langley had allowed his officers to leave right in the way. Daniel Shaver collapsed on that purse when he was shot. He was negotiating over that purse. Sergeant Langley could see it. Officer Brailsford could see it. They could all see that someone was going to have to move an arm, would likely be moving over that purse in a way that Sergeant Langley had indicated would result in a shooting. They also saw another thing. They saw his pants falling down. They were 6 feet away from him when he was shot. His pants were falling down off his backside already. His waistband was exposed, his underwear was exposed. And Sergeant Langley could not credibly or plausibly contend that he believed he still had some sort of weapon secreted in there, or that it was appropriate to even have an officer under those sorts of rules of engagement and commands with that sort of proximity with the individual crawling toward them in a position where they were going to have to raise their hand to either pull up their pants, negotiate over the purse, or do something that he had told his officers would justify shooting. I hope that answers your question, Your Honor.
I hear the story, but I'm really not sure it does answer the question, because the question is, if I understand that there are cases where commanding officers are held responsible for setting up rules that are followed. In this case, defendant claims that there isn't an allegation or a basis to conclude that the rule wasn't followed, thereby pointing the finger at the officer who fired the shot as having transgressed the rules that Officer Langley set up. What case speaks to this kind of situation?
Your Honor, first of all, per our complaint, Officer Brailsford followed exactly the rules that he was given, exactly the instructions he was given. However, Judge, I would point you to the Book decision, for example, where an officer who decided that lethal force himself, he did not believe it was appropriate, he fired his beanbag weapon instead, wanted to see if that would work, decided that he didn't believe lethal force was appropriate at that time. Nevertheless, the court held that he could be liable as well as an integral participant in the conduct of other officers who were there with him, who then fired deadly shots with their rifles. I think that's a good example of that, Judge. And with that, Judge, I don't think I have anything to add. Unless you have questions, I think I'll turn things over to Mr. Budge.
Very well, thank you.
Okay, thank you.
Good morning, Your Honors. May it please the Court. I'm Sven Budge. I represent the plaintiffs, appellees, Grady and Norma Shaver in this matter. And I'll be brief, but I want to join in the arguments that Mr. Richards has proffered already, that those apply to my client's claims as well. I would add a couple of things, though. Regarding what's clearly established, there's several cases that this Court has cited, and the judges, Your Honors, have questioned which cases in particular. There are cases that were cited in the briefs. Some of them may not be specifically for facts that are relating to this case. However, the Court gives guidance on what constitutes an integral participant. So we cited to Boyd v. Benton, for example, and in that case, where officers are full and active participants in a constitutional violation by providing armed backup to another officer who directly causes the deprivation, the officers may be liable as integral participants. Another case is Hopkins v. Bombasino. They give, now that may have been an unconstitutional search warrant, an unconstitutional search. However, there's examples given in that case. Says, for example, an officer who stands at the door armed with his gun while other officers conduct the unconstitutional violation. In that case, it was a search. They are integral participants in the constitutional deprivation. So there's several examples that are given within those cases that state, even though this isn't the exact circumstance, it's not an unconstitutional search, it states in those cases that standing there as armed backup, which we know Defendant Langley had his AR-15 out as well and was backup, makes him right there in just that an integral participant. Add on top of that that he's the one that gave all the commands, he's the one that organized the immediate action team, he's the one that selected what the officers would be doing, who would be lethal force, who would be cuffing. He decided all of that. I don't know how we can stand back and say he's not an integral participant when he was the leading participant. Maybe he wasn't the one that pulled the trigger, but he's the one that set in motion all of the circumstances and everything that happened that led to the trigger being pulled. Another thing that I would add is if we look at the overall purpose of qualified immunity, it's meant to protect police officers in their discretionary actions when they're not sure if what they're doing violates a citizen's constitutional rights. I think it's clear, and this is, in my opinion, and alleged in the complaint, this is an obvious case of not shooting an unarmed man. There's several cases that cite to that. Tennessee v. Garner, that you may not seize an unarmed, non-dangerous suspect by shooting him dead. There's several other cases that I could go and cite, but clearly, based on the pleadings, Daniel Shaver did not pose a threat. He was complying with the officer's commands to the best of his ability, even though those commands were not only contradictory, but nearly impossible to follow. How you crawl with keeping your hands in the air and not putting your hands down, crawling in and of itself necessitates putting your hands down. That right there, based on Sergeant Langley's commands, if he puts his hands down, he could be shot. Then he orders him to crawl, which necessitates putting his hands down. And when Daniel Shaver attempted to speak, he was told to shut up. He was not allowed to say anything. He was not allowed to clarify. He says in there, I'm just trying to presumably do what you say or understand. He's cut off when he says, I'm just trying to, by Sergeant Langley, and says, don't talk, listen, do what I say, and tried his best to do exactly that, even though it was nearly impossible for him to do that. In this, I'm requesting that the court affirm the district court's denial of qualified immunity on that grounds, and I guess if you have any questions for me on that point.
Thank you, counsel.
Thank you.
Let's give a minute and a half.
Thank you, Your Honors. I want to emphasize again the pleadings here. the plaintiffs have alleged that the decision to shoot was Officer Brailsford's alone. So accepting the pleadings as true,
Say it's his decision alone.
at paragraph 114 of the suite plaintiffs, they allege, quote, Daniel's killing was therefore unprovoked, unwarranted, unjustified, callous, depraved, vicious, and evil. It reflected a conscious decision by defendant Brailsford to shoot an unarmed, innocent man who was complying with police officers, sobbing, begging not to be shot.
Does it use the word alone?
Again, Your Honor, accepting that is true, it was his decision, and then the
Right, but
paragraph.
you said the complaint said alone.
So
Does
the paragraph right above that, it doesn't use the word alone, I apologize.
Okay,
But
well,
the paragraph above it says, no other officers present fired their weapon.
Well, we know
And it goes
that.
on.
But the whole point of this case is they're saying that this guy, your client, set the table for this to happen. When you can't come in here and tell us the complaint says he did this all alone when the complaint doesn't use the word alone.
Again, this is an objective standard, so how do we judge objective? There were other officers who were armed who did not shoot. So to say that these commands, which were not commands to shoot, they were commands to comply, were perceived as orders to shoot, we know from objective evidence, as alleged, other officers did not shoot. Just two other very quick points.
Yep.
As alleged, there was a plan, and that's found at the suite plaintiffs' paragraph 85 and Shaver's complaint at paragraph 34. And that plan was to approach the room and to take into a custodial investigation. There was no plan to shoot any unarmed individual. And again, this court has emphasized over and over again that to be an integral participant, you have to have a knowing participation, a collective decision to use these unconstitutional force. And as the plaintiffs point out in Boyd, this court did find that there was a knowing collective decision. They all knew this flashbang was going to be used before they went in, and they were found that was unconstitutional. But again, this court said that wasn't clearly established at the time, and thus, although in the future it will be a constitutional violation, these defendants are entitled to qualified immunity. Officer Langley is entitled to qualified immunity as alleged. Thank you, Your Honors.
Thank you, counsel. Thank you both for your argument in this case. This matter is submitted.